All due respect, like I said, I don't have anything personal against this court. I'm not a corporation, right? I'm a natural person. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony.
A self-proclaimed sovereign citizen recently caused quite a scene in court, and let me tell you, he was anything but calm. The entire reason he ended up in front of a judge? He thought he could drive without a license, as if traffic laws didn't apply to him. What really caught me off guard was how the judge handled the situation. It was definitely unexpected. I won't spoil too much, but let's dive into this wild courtroom moment. Feel free to share your thoughts in the comments about what you think was going through this guy's head. As the hearing continued, the same person,
All due respect, like I said, I don't have anything personal against this court or anything. I just request that this court adhere to the supremacy clause of the U.S. Constitution and hold that these state statutes in which they have me charged with are constitutional based on the U.S. Supreme Court. And what is the case? The Shaney versus Winnebago Department of Social Services, there was a young child whom the mother relays that the father was beating the child and the child died. The mother sued all the way to the U.S. Supreme Court. And the U.S. Supreme Court held that no matter how bad or gruesome that this case was, when it concerned the case, that the states have no duty to protect citizens from other citizens. Anything that compels performance, there has to be a contract. And again, I reserve my rights under UCC 1-308 and the common law UCC 1-103.6. And it's clear, Your Honor. And I ask that this court, do their sworn fulfill their sworn oath under the Michigan rules, the Michigan Judicial Code of Conduct. The court is not to be swayed by public opinion or what the people may think or whatever it may be. Like the great honorable Judge Dalton A. Robeson. So every government is entitled to a Republican form of government, not a corporate. I'm not a corporation, right? I'm a natural person. The case law clearly breaks everything down, which everyone is in default. I just ask that this court dismiss this case at this juncture. If the court does not, I demand under the supremacy clause, the subpoena power of this court, to have Ken Worthy brought in so we can have an evidentiary hearing. Because how can a criminal prosecute or allege that I'm a criminal when they're committing all the crimes, Judge? Since I've been home, I've been making reports of police and other things, violations of law against me at the precinct. And no one listens to me. They just ignore me. But when people call and say, well, hey, Mr. McCrary did this, Mr. McCrary did that, they come, then it's found out nothing happened.
Under our state constitution, this court has jurisdiction. Furthermore, as far as discovery goes, I personally sent Mr. McCrary twice, and I have the emails, copies of the emails to show that that's necessary. Dates are not on here. May 24th, which was last week, and May 5th.
Really sticking to his beliefs, kept insisting on his version of reality. At one point, he claimed he hadn't deleted some key emails from the prosecutor, even though the evidence suggested otherwise. His confidence in denying the obvious was almost impressive. The sheer determination of people like this can be baffling, even when their arguments don't hold water. Watching him argue, though, you can't help but wonder, is this stubbornness, or does he truly believe he's right? Let me know if you think his commitment is admirable or just plain frustrating. Then came the moment where he tried citing case law to back up his claims. The kicker? The cases he referenced didn't even apply to the situation. He even argued there was no victim or weapon involved, completely missing the point of the hearing. The prosecutor had solid evidence, and it was clear to everyone in the room.
No, I'll give you, it's gonna take a couple seconds. One of those emails, the E is missing in there.
That's not my fault. They violate your order. Yes, ma'am.
Okay. So you should have received one of them.
Nothing.
Right, and neither one of them came back as bad email.
Okay. All right, so Mr. McCurry, I don't know why you're not receiving discovery, you did not receive it.
He didn't send, can we subpoena Google and,
No,
litigate this and
This is
show that he
not,
hasn't
this
sent
is not a
anything?
trial, this is not evidence you're hearing.
Well, can I say one more thing?
After we get done today, we confirm your email address. You can even send a test email to make sure that he received it.
Well, he did. It showed me that he got my paperwork. He admitted in the last receipt that he received my
Okay,
paperwork.
and
So why would he send it? Well, not, why wouldn't I get it back? My email is legit. It's my phone right here.
okay,
Also a jurisdictional challenge.
let's,
Right?
before we get to that, Adrian Intercessor, you want to respond before we forget?
Yes, Your Honor, I do want to make a record. You know, this defendant has already availed himself to the jurisdiction of the courts of the state by admitting to having a driver's license. And also further add that the 10th Amendment has allotted and given police powers to the states, which then allows the state to create criminal laws under which this defendant must avail himself to. I further add that, again, as the court has acknowledged, that this defendant has at least once received the discovery to his emails, to his correct email. So any more allegations of not receiving discovery would be improper, given that we have it at least proven that he has it at least once. And there have been no additions or corrections since the discovery was done the first time.
Okay,
May I
Mr.
respond?
McCurry, I'm gonna wrap this up, you can respond and.
Yeah, just briefly, if I may.
Sure.
Well, this young lady here to basically
Mr. Sessions,
respond, Mr. Sessions, to respond to her statements in Michigan, they're locking people up for not having a driver's license. I was compelled.
there are people getting
But I
locked up
reserve my
for
rights. This was the
murdering
law.
people as well.
Pardon?
People getting locked up for murder as well.
Well, I understand that, but what I'm saying is the corpus delicti, they're going off written statements. You know the corpus delicti rule under the Michigan Supreme Court case, as well as the federal court case. Where's the body of a crime? They're saying ammunition, all this, that. Where's the guns at? Where's the victim at? Strangulation, where's all this? Where's the medical
I wouldn't
reports?
know because we haven't
And
had an
then,
exam.
okay, but no, jurisdiction, once it's challenged, it must be proven by the people. This is state and federal law, from the Michigan court.
Yet this individual just kept interrupting, making the proceedings drag on unnecessarily. Honestly, it's moments like these that leave you shaking your head. Do you think he's clever or just overconfident? Cases like this highlight why the legal system often feels slow and inefficient. Real victims with legitimate cases are left waiting while time is wasted on baseless arguments. The law is straightforward. If you drive, you need a valid license. Yet, some individuals insist they've uncovered loopholes that simply don't exist. Watching them confidently argue against well-established laws can be equal parts entertaining and frustrating. In the end, though, it's never successful. So, what do you think? Are people like this genuinely convinced they're right? Or are they just trying to game the system? Let me know your thoughts. And if you found this breakdown interesting, don't forget to like and subscribe for more insights. Thanks for watching.
I'm demanding that jurisdiction, I mean, they're already in default, but still, again, I'm demanding jurisdiction be challenged, personal subject matter and territorial jurisdiction. Even when I was in prison, I had interactions with Kim Worthy, chief prosecuting officer for the state. I reserved my rights then in prior proceedings, as well as I was compelled to obtain a driver's license. And I reserved my rights. That's all the law mandates, that I reserve my rights, which I have done. And right now, this lady, Mrs. Prosecutor, I can't remember her name, and Mrs. Sisson, Esquire Sisson, and this gentleman here, they're in conspiracy and violating federal and state law. They're committing crimes, and I demand that their oath of office, their law, their license to practice law, amongst other things, be given to me, as well as their bond, as well as you, Judge, Your Honor. Also, like I say, jurisdiction has been challenged, and they have to prove it first based on the case law, which I have noted in this paperwork. They can't get around that. We can say, well, yeah, they're talking about reserving rights and all that. Okay, but still the law from the state Supreme Court, Court of Appeals, and federal jurisdictions clearly mandates that once jurisdiction is challenged, the person asserting jurisdiction has to prove it. And all they have is statements. Under the corpus delicti rule, out of court statements is not evidence, so these charges should be dismissed. Where is the body of the crime, Judge? You went to law school, you're a practitioner.
I don't know because I haven't heard testimony to know.
Well, that's not how it works with jurisdictional
That's
challenges.
how, you know, that way. So, do you have any last
Well, I would
preliminary
like,
statements, because I'm getting ready.
okay, I would like to challenge jurisdiction again, which I have done from the onset of this case, personal, subject matter and territorial jurisdiction. State and federal case law is clear, in which this court being inferior to the higher courts must adhere to their oath of office, their bond, and so on and so forth, their license to practice law and the Michigan rules of code of judicial conduct, and must compel the people to prove jurisdiction, which they're asserting. Where's the proof? You have to show this court. That's at any stage of the proceeding, the law allows that.
Okay. So on discovery, I saw paperwork confirming the email address that you provided to the court is now the record, that discovery was sent. I'm not sure if it was an email, please don't interrupt. If there's another email you would like to be sent to, I will ask the prosecutor to do so. 2, for requesting license numbers from everyone. My name is right here in front of you. You go right on State
I
Bar.
ain't saying nothing.
RP numbers are available for you to look up as they are for any general public, okay? As far as venue, jurisdiction, and you mentioned this, you don't know whether I was appointed or elected, I was both.